wife of the brother, or of father's or mother's brother, or of grandfather's or grandmother's brother of the other, if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or two sisters, for the
So
purpose of
they cut out the schedule bit
There's no schedule.
because they improved on it, and I think they worked out the relationship. If you look at this, I think the Special Marriage Act is the template upon
Yeah.
which this was built.
Your Lordships are right. So for them, my lord, for Special Marriage Act, there is a separate schedule. Here it is statutorily incorporated in the definition.
Definition would incorporate everything there.
Another, my lord, interesting thing, my lord, explanation 3, relationship by adoption as well as by blood. Nothing may perhaps turn on this, but this is another distinction.
And then they brought in the Sapinda relationship in 3F of the,
Yes, my lord.
and incorporated the prohibition in 4.4 and 4.5. So this is, SMA is a little more elaborate because it then lists out categories which are absolutely within the,
Yes.
they don't leave it to Sapinda, because obviously SMA is religion neutral. Therefore, they itemize the relationships.
But borrowing the concepts from Hindu law.
Actually the same.
Borrowing concepts from Hindu
Borrows
law.
it from the Hindu law.
Because this Sapinda and Sagotra is essentially, my lord, concepts of Hindu law.
Yes.
But in some communities, there is a custom which permits that. And that is also
That is excluded, huh? There's an
Section
exception.
4 actually says that, proviso.
Yes, therefore they
interesting
take
part.
care of that as well.
Actually, anticipating that was brought in only in 63.
Yeah.
63.
Which
But
meant
by
that
way
for
of an
10
amendment.
years, for 10 years, this prohibition continued.
Yes.
So, for instance, mama, you can, some communities are mama,
Niece,
niece,
Mama and
even
niece,
cousin.
cousin, sister's daughter.
Sister's daughter.
Mama's Bhanji and son can get married. Possibly, but I inquired.
That is still protected because the custom protects.
Custom and the custom, the origin, nothing to do with this matter. The origin of the custom was that earlier the daughter-in-law used to be troubled in the household of the husband. So if Mama is the father-in-law or Fufi is the mother-in-law, then she would be like a child only. That was the reason why, my lord, this custom.
There were many sociological.
There are sociological good reasons, my lord.
Land is another issue.
Land.
Mostly
probably.
land is the issue.
Keeping the property.
Yeah, land is other issue.
Land of the.
Bifurcation.
My lord, now kindly see 4C. And my lord, read the way they want to read it. It would be as absurd as, my lord, I would sound while reading this, my lord. Please see C. This is a compulsory precondition of a valid marriage under the Special Marriage Act. The male has completed the age of 21 years and the female the age of 18 years. Now we read person. The person has completed the age of 21 years and the person has completed the age of 18 years. It doesn't make any sense unless your lordships rewrites that for same male sex 21 years, same female sex, but then again, my lord, it doesn't take care of other my lord, categories like transgenders, others, my lord, who are not either male or female. But then kindly see proviso, provided that where a custom governing at least one of the parties permits of a marriage between them, such marriage may be solemnized, notwithstanding that they are within the degrees of prohibited relationship. Your lordship, my lord, kindly leave that and kindly come to, my lord, now section 11. Section 11. I am showing, my lord, the heart and soul, the basic infrastructure of architecture of Special Marriage Act is between a conventional biological man and a conventional biological female. Lord, section 11. Declaration by parties and witnesses. Your lordship gets, my lord? 11. Section 11, my lord.
When you go to the third schedule, right? Declaration.
I'm sorry, my lord, my learned friend is right, my lord, my learned senior is right. My lord, please see section 4(2). 4(2). Though capable of, my lord, this is again a condition, precondition of a valid marriage. Though, my lord, B2, your lordship gets, my lord? Though the capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of children. But procreation word used statutorily necessarily mean a union between man and woman.
That may or may not be, in the sense, I'll tell you why, that the emphasis in that provision is not on procreation as much as on mental illness.
Correct, my lord. But
Lack of mental
mere mental.
We're getting the drift of your argument, but this point, this particular provision may be a little different actually.
But my lord, mere unsoundness of mind may not be enough. If one of them is
I'll tell you why, solicitor. In the case of a heterosexual couple, the fact that one of the spouses cannot procreate does not render that an invalid marriage. Suppose the girl in a heterosexual marriage, suppose she has had a hysterectomy when she was a child, she can still have a valid marriage.
Correct. I take it.
See?
Lord, please come to 11, section 11. And I think my Lord Justice Bhatt saw the form also, my Lord. I wanted to show that form, my Lord. Section 11, declaration by parties and witnesses. Before the marriage is solemnized, the parties and 3 witnesses shall, in the presence of the marriage officer, sign a declaration in the form specified in 3rd schedule. Please see, my Lord, 3rd schedule. Lord, if we have the same book, it's at page 26.
Yes.
This declaration is to be found, is to be filed.
You're referring to clause 3, not related?
No, my Lord, I'm on the title itself and clause 3 as well. Declaration to be made by the bridegroom and declaration to be made by the bride. The act is not gender neutral. And 3, as your ladyship rightly says, I am not related to CD, the bride, within the degrees of prohibited relationship. So bride's mother is not my relative, etc. Lord, just when your lordships are there, see the 2nd schedule also. Just above the 3rd schedule. The notice of intended marriage. I am not on the legality of notice, but I am just showing the gender issue. Your lordships gets scheduled, 2nd schedule. It says unmarried, widower or divorcee, and for the bride, unmarried, widow or divorcee. So not only your lordships will have to rewrite the act, your lordships will have to recast even the forms, statutory forms.
Mr. Mehta, that's in para 1 also of the 3rd schedule. What you're reading in the 2nd schedule is in para 1 of the 3rd schedule as well.
Yes, your
Yeah,
ladyship.
you're right. वो वही आ जाता है.
Widower or divorcee or lady.
Right.
Description of the party. No?
Yeah. Which is the next provision, Mr.
Yes. Now, your lordships may come to 19. Lord, I forgot to show, my Lord, during the constitution, this parliamentary debates, one of the debate why, my Lord, this act was enacted was that earlier, the previous Special Marriage Act required me to denounce my religion.
Renounce the man.
Yes, denounce my, if I get married, my Lord, under this act. And that was working as a deterrent. And therefore, 19 continued, but thereafter it was taken away under 21A. That's the distinction, and that's why, my Lord, I say that personal law gets re-entry through 21A. Please see 19. Effect of marriage on member of undivided family. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religion shall be deemed to effect is a severance from such laws. No, two things.
Just read also, sir, 21, before we read 20.
Only kindly pause here for a minute. 19 says that persons belonging to Hindu, Buddhist, Sikhs, and Jain will renounce they would not be a part of Hindu family, but Muslim personal law continues to apply, Parsi personal law continues to apply, Christian personal law continues to apply, except in succession, which is 21.
That's right.
Yes.
Now, below 20. 20 may perhaps not have much relevance. I'll just read it. Right and disability is not affected by Act. Subject to provisions of Section 19, any person whose marriage is solemnized under this Act shall have the same rights and shall be subject to same disabilities in regard to the right of succession to any property as a person to whom Caste Disabilities Removal Act applies. The caste, my lord, were recognized earlier, and that there were certain disabilities which were removed. So, my lord, that rightly, my lord, in the present context, my lord, may not have much relevance. Please see, my lord, 21, where Succession Act is made applicable, Indian Succession Act, across religion, but not other personal laws of Muslims, Parsis, etc. And Christians, my lord. Not, I'm on 21, my lord,
Yes.
Chief Justice, my lord, wanted. Notwithstanding any restrictions contained in the Indian Succession Act with respect to its application to members of certain communities, there are chapters applicable to Parsis, Christians, etc. Notwithstanding that, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purpose of this Act shall have effect as if Chapter 3 of Part 5, Special Rules for Part C intestate, has been omitted. So, my lord, Muslims continue to govern by their personal laws,
Yes.
except in case of succession. Now, my lords, personal laws even for Hindus, which were taken away in 19, comes back in 21, because they found that this is deterrent.
Personal law, no? 21. See, the thing is for 20, 21 years, they realized that this is working
To the it's deterrent.
deterrent.
That I want to marry under Special Marriage Act, but I don't want to renounce Hinduism.
Eventually you might be accepted by a family
Yes.
and you are cut out. So therefore,
By law, I am cut out. The society, my family would accept me, and
but law, you're excluded. Therefore,
yes,
therefore they brought it at par. So in that sense, there is equality among all.
correct. So, my lord, where the marriage is 21A, solemnized under this Act of any person who professes the Hindu, Buddhist, Sikh, or Jain religion, which a person who professes the Hindu, Buddhist, or Sikh or Jain religion, I have to marry Hindu only. Then only 21 would apply. Section 19 and 21 shall not apply, and so much of Section 20 as creates disability shall also not
So,
apply.
Mr. Solicitor, 21A lifts the prohibition or the
19.
disability which is created by 19 only where a person who is a Hindu, Buddhist,
Marries a Hindu.
Sikh marries a